Authorised.
Yeah, this Bingham, you'll have to excuse my voice, I have a cold.
My learned friend Dr. Lloyd Barnett appears for the respondents. My learned friend Miss Gale, Mr. Letman and I appear for the appellant. My lords, can I make a few introductory comments? We say this. First, this is a case where the Court of Appeal applied the wrong set of procedural rules by purporting to apply Part 13.3 of the CPR. Secondly, that when they did have regard to those parts of the CPR which were capable of applying to this case, namely the overriding objective, they didn't apply that part. And thirdly, the order for specific performance that has been granted, we submit, in respect of a non-existent contract which will affect the person with a real interest in the property, Miss Hines, whose rights have been upheld in a series of other cases. What I propose to do...
Yes, perhaps I misread the judgment of the Court of Appeal, but they appear, despite the rather draconian nature of the rules that on one view applied, they did appear to apply an overall discretion, didn't they?
Well, my lord, I'll come to that, because there's an issue between my own friend and me about which rules apply, and then what, in fact, the Court of Appeal did. It's certainly capable of reading one reading of the Court of Appeal's judgment, falls with what your lordship says. But if you look at the critical paragraphs 30, 31, 32, because in fact they renumber and start going back on just in terms of numbering, we respectfully submit that it's perfectly apparent that they must have applied the draconian provisions. Otherwise, they would have ended up by setting aside this judgment. Because when one's looking at the merits of this case, we respectfully submit the merits are overwhelming as to why this particular judgment had to be set aside. But perhaps before I get into those aspects of the actual merits of the case, I can take you through the record, because it is, I'm afraid, very difficult to follow. What I have attempted to do is put everything in something called an outline chronology. And it's called outline chronology because even now I'm not confident that it would be in any sense comprehensive of all the material. But what I hope it will do is save a bit of noting and also enable me to make relevant points on the merits. Because to address your lordship's point at the beginning, we submit that if the Court of Appeal had approached this in a traditional Evans and Barkman way, or with an open textured discretion, there is no proper way for coming to the conclusion that they did come to. Miss Hines' interests would be completely defeated by what has happened this long after the event. Can I start, though, on the outline chronology by taking your lordships to pages 11 to 13 of volume 1 of the record?
Pity we didn't have this yesterday.
Sorry?
Pity we didn't have the chronology before.
Mr. Diggins, even before you start, can I just ask you one thing? That there is some suggestion, I think, in Dr. Lloyd Barnett's case, that there may have been some pre-existing agreement.
My lord, what I'm going to do, your lordship's absolutely right. What I'm going to do is take you through the outline chronology from the record, and then my learned friend has further affidavits which were adduced in the Court of Appeal, which for whatever reason didn't get on the record, which I'm going to then put into the thing. But your lordship is right. There are... nothing is straightforward, and I will show you the material. And that is perhaps why it's still outline chronology. But at the moment, this is from the record, but I am going to take you to the other materials.
Thank you.
Can I just take you to PC 11? And you can see from the date is at the top, 27th of June, 84. The vendor is described, the vendor was described as Tomlinson and Silvera, both of an address in Kingston, and the purchasers, the respondents, Paul Piccott and Eugene Piccott. And the description of the property is all that parcel of land known as flat number 3, part of 26 Silverdene Drive. So it's only flat number 3, 26 Silverdene Drive here.
And how many flats were there?
It appears, my lord, that there were 4. And I'll hope to make that proposition good later on.
And was there a sale of those, or a purported sale of those?
There appears to have been a purported sale of one of them, because there's litigation with the Dohertys, and there does look as if 2 other purported sales took place. But what actually happened to those, goodness only knows, because as you'll see from the chronology, what happened is that they all effectively came through, or appear to have come through Tomlinson and Silvera, and then the others were all then sold back, came back to the O'Connor, who then made sales back to those individuals.
Mr. O'Connor was he the registered proprietor of these?
Yes, by reference to the folios. If you look at, in fact, to answer that question, my lord, if you look at the description of the property, the folio is blank, but in fact we pick it up from later descriptions. All that land comprising certificate of title registered at folio, volume X and folio, because it's still the old way of registering land there. But part of the problem was that there was no effective subdivision that was ever registered.
So they were one title, were they?
Effectively, my lord. And the closest we get to a description of what happened will be from Mr. Silvera's affidavit, and I'll show you that. Can I just ask your lordships, though, to note that the purchase monies are $95,000. That's because when one comes to look at the agreements that are referred to later on, different figures are given, and the deposit was $9,500, as one might expect. There's nothing else, I think, that's material from that.
And that, excuse me, that deposit was paid, was it?
It appears some monies were paid, whether it was paid as a deposit, but certainly sums in excess of that appear to have been paid to Silvera, as appears from his later affidavit, and I'll show you that. Can I then take you to page 40, which is the next date in the chronology?
I mean, who takes possession of the property?
I think the fairest thing I will is to show you the evidence, because there are suggestions...
Well, what's your case on who takes possession?
Well, it looks to have been as if it was vacant for a bit. Maisie Hines went in, but I'm well aware that the Piccotts had claimed that they went into possession for a little bit.
They say they did some work on the property, didn't they?
Yes, my lord, and I'll show you where that comes from. Because the next agreement is page 40, agreement for sale and purchase, where the agreement date is blank. And you can see that the vendors here are described as Paul and Eugene Piccott, who give their address as 26 Silverdene Drive, which at least is a part answer to my lord's question. And they give their names, their professions as a property manager and a factory operator who's retired. And then the purchaser is Maisie Hines, and the short description of the property is flat number 3, 26 Silverdene Drive. And the purchase price is now $240,000. And you can see that a provision is made for a deposit of $10,000.
What currency is that?
Jamaican dollars. The Jamaican currency, my lord, is maybe well known or not well known, effectively suffered a collapse at around a bit later than this, but at the moment, to get the currency exchange rate, you divide by about 140, isn't it, to get a pound? Yes. but at times it used to be only $20 to the pound. And so you can understand the devastation that must have wrought on the economy. And I'm afraid I simply couldn't attempt to convert it fairly for your lordship back then. Can I then take you to page 75 of the record, which is the...
Yeah, I made a note which was that this agreement to sell was sometime in April 1988. Is that right? That's right.
Yes, my lord. That's all consistent, I hope, with the chronology.
Yes, and somewhere it's referred to as March, but it doesn't really matter.
No, nothing turns on the difference, but your lordship's absolutely right. In early 88, this agreement was made. I'll show you some references from the documents. Can I then take you to page 75, which is where Mr. O'Connor, as plaintiff, brings proceedings against Mr. Silvera as defendant. And because there's an issue that's arisen on my learned friend's case about what's described, can I just show you what we've got here? It's in usual terms at the beginning, and you can see that just at line 19, by this summons, the plaintiff claims against the defendant for a determination of the following questions. Whether Mr. Silvera, being the plaintiff's attorney at law and an employee of the law firm Silvera and Silvera, could in law secretly purchased the plaintiff's property situated at Silverdene Drive and registered, and there's where you get the registration for the whole of the property, which is volume, I've read it as 968, folio 681, but I'm not sure very much turns on that, other than the accuracy obviously of the description. Without the plaintiff being advised to seek independent counsel. And then B, whether Mr. Silvera, an employee, could validly sell the premises to third parties, which obviously specifically engages issues which are raised, at least in this appeal, and keep the profit to themselves. And then you can see the declarations that were sought. And it may be, I think, that the confusion in my own friend's case has arisen because A and B is used twice, as it were, for the determination of the questions. And the declarations, where the plaintiff's attorney at law and employee of the attorney at law secretly purchased the premises without advising him as who the purchasers are and seeking independent counsel, that such purported sale was void, which purports to be comprehensive, obviously, of any third-party sales. B...
I mean, there is an issue about what that really means, isn't there?
Of course, my lord. If any of this was straightforward.
But it's one thing to say that the agreement wasn't binding on Mr. O'Connor.
Yes.
And another thing to say that anything was actually void as a contract.
Indeed, which is why it's important to look at what everyone else thought. And indeed, if you are dealing with third-party rights, I mean, proper procedure, which, and this isn't restricted only to the appellants, the respondents have made errors as well, would have suggested that everyone ought to be before the court. But this is what we've got, as it were.
So the assertion here, though, is that Mr. Silvera was the plaintiff's attorney.
Yes. Well, yes, that was
so it's accepted that he was his attorney, is it?
Yes, yes, and I'll show you some evidence of that. He was his attorney, but what he'd been asked to do and what he did do, and whether he was entitled to sell, etc. And that declaration, can I just ask your lordships, as it were, to put a tick by it, because it's just easier when I come back, because that declaration is granted by Mr. Justice Harrison. The second declaration, little b, that such action of Melbourne and Silvera amounts to a breach of confidential and fiduciary relationship between Silvera and the plaintiff, and that any secret profit made by him should be disgorged and handed to the plaintiff forthwith. Can I just ask you to put a cross by that, because that wasn't granted. But just perhaps ask you to note at the bottom of page 75 the capitals which were alternatively, which may explain, because we don't have a reasoned judgment from Mr. Justice Harrison, exactly why that one wasn't granted as well.
Sorry, I didn't follow that. Could you say
Sorry,
that?
my lord. If you look at the bottom of page 75,
75, yeah.
you can see that the B is alternatively.
And Mr. Justice Harrison granted A but not B.
That's right. And then if you...
Which is, I mean, on the face of this document is the right thing to do because these were reliefs sought in the alternative.
Yes, yeah, absolutely, my lord. And then if you wouldn't mind putting a tick by C, which he did grant as well, that the defendants hand over all such documents pertaining to the said sale forthwith to the plaintiff. D, that the defendants be condemned in costs was not granted. E was granted, that the defendants render to the plaintiff a full and accurate statement of account of all receipts and payments made in respect of any transaction pertaining to the premises, and then further or other relief. And that was the, as it were, originating notice of motion which commenced the proceedings.
And was a full and accurate statement of account rendered?
Can I take you to page 196C? No, my lord, really, because I did think so for part of the time, but in fact there are issues even as to what occurred on this. Because the next date you can see is the 19th of March 1990. This is solely from the record at the moment. But when we come back to look at the chronology and write the further document, we'll insert just 2 dates here. And this is Melbourne Severa's affidavit.
Page, I'm sorry.
Sorry, my lord, 196C. Just...
And was there a trial?
My lord, the difficulty is, although I'm assisted by Miss Gale, who first became involved in this matter when dealing with Miss Hines' interest in it, and then began to represent Mr. O'Connor, she wasn't representing Mr. O'Connor at the time, and we're not able to answer that by reference to anything. What I can tell you now, my lord, is that there were contested affidavits that were sworn, and I'll show you later with the further material my own friend very kindly has managed to locate where the other 2 affidavits are. But
why can't we have those as we go along?
oh, well, I mean, you can have them now, my lord, but it's just in terms of giving you the material. If it's all right, I'd rather come back to at the end, because it complicates matters at this stage. Although, well, all right, what I'll do, can I hand up my own friend's affidavits, and we'll deal with those.
Well, speaking for myself, it seems to me it'd be better to have all the material as we go through.
Certainly, because even this there are problems with, because, yes.
Their affidavits.
You may have seen a reference to part of this affidavit in the judgment of the Court of Appeal. And in fact, this is just the letter that was obtained from the Registrar of the Court of Appeal, who said, we didn't actually, these weren't part of the record, but given they've been referred to by the Court of Appeal, or at least part of it's been referred to by the Court of Appeal, one might wonder why they didn't form part of the record. And then you can see, I hope, 2 affidavits. The first is dated the 26th of September 89, and the second is the 23rd of April 1990. So, in fact, my lords, if you wouldn't mind writing in on the outline chronology, just above the 27th of April 27th of September 89. Could you just write 26th of September 89, and that's the affidavit of the appellant.
What, in support of his application?
I mean, the chronology almost proves that point. Yes. And you can see, if you look at it, he says, I reside in Kingston. Prior to 83, that's obviously important wording, and we'll deal with all. Prior to 83, I was the owner of premises at 26 Silverdean Drive, and I exhibit a copy of the title. For many years before that, I was a client of Silvera and Silvera, who were attorneys who still work for me. Sometime in '93, I experienced financial difficulties with my bank. Consequently, I went to my
Sometime in
attorney.
83.
Sorry, my lord, you're quite right. It must be 83, sorry. Yes, 83. Went to my bank. Consequently, I went to my attorneys and spoke to Mr. Silvera, told him of my difficulties and that I proposed to sell the premises. Consequently, Mr. Silvera went and viewed and placed a value of $225,000 on it. On the 29th of June...
That's the whole property?
Yes, that's, as I understand it, comprehensive of the 4 flats plus a little bit. And a little bit, you'll see, comes a bit later. On the 29th of June, I signed an agreement for sale in respect of the property at the offices of Silvera and Silvera. There were no purchasers inserted in the agreement, but later I learned that the purchasers were Tomlinson and Silvera. Now, we've never been able to find that agreement at all, but obviously that suggested that that was what he was going to do, was do a sale. Whether he achieved that is, of course, critical to what comes later. As a consequence, Silvera advanced a sum of money to my bank to liquidate the mortgage and advised me that the apartments, and that appears to be exactly the same wording for the flats, were rented out for a sum of money, and from this sum he gives me $1,000 to $2,000 per month, and from the monies he receives he services a loan. So it doesn't look at this stage as if he's saying that the transaction's been completed. But about 4 years ago, and this is obviously sub-sales, Mr. Silvera asked me to sign 4 agreements for sale in respect of the flats. This I did, but he never delivered any of the agreements for sale to me.
And these are what agreements? Who was stated to be the seller in this agreement?
I don't know, my lord. I only infer that because he was asked to sign them, and these are obviously critical issues for the issue of who was selling, whether there'd been ratification or it was agency, etc. I'd only inferred that it must have been him signing as vendor, simply because otherwise why would you get him to sign them? But he then, and again, we don't have copies of those agreements. Sometime in the middle of 1985, I was informed and believed that the premises were sold to 4 purchasers for $130,000 each. But that due to some technicalities, the premises have not been transferred, hence the whole process is still pending. And I exhibit one copy of, a copy of one such agreement for sale, marked KO3. I'm afraid we don't have that. We've asked, but we've not been able to find it. And you can see at this stage, he's talking in terms of everything being still pending. But during the discussion leading to the purported sale in '83, I was not advised by Mr. Silvera to seek independent counsel, neither has he advised me of the sale price nor any terms and conditions. That if these sales are concluded, so he's obviously still talking in terms of future, so far as his understanding is concerned, whether that's right is a different matter. Silvera and Tomlinson stand to gain by way of secret profit, and then he says what they'll gain, and I don't need to trouble you with the figures, fortunately. And therefore, I pray that this Honourable Court will be pleased to grant me the following declarations. And you can see A, C, D, E, F from effectively mirroring, at least in part, what has been set out in the notice of motion. So that's the first date, as it were, to be inserted, I'm afraid, in manuscript, and I'm sorry it comes all so late, into your outline chronology.
Sorry, Mr. Dingless, is the effect of this evidence then that Mr. O'Connor signed no less than 5 agreements? First of all, an agreement relating to the whole thing on the 29th of June '83, and then 4 further agreements, presumably relating to each part of the whole.
That certainly appears to be the effect of it, my lord. The first one appears to be blank. The second 4, if I can call it that sense, seem to be to 4 purchasers for $130,000.
Well, those things seem to be mutually inconsistent.
Yeah,
of course. Yeah. none of it.
And you said it was a sub-sale, but I mean...
Well,
It's a second sale, isn't it?
yes. Can I show you all the evidence and try and make submissions on it? I mean, I'm not sure, unfortunately, I will be able to answer every question, proper question that is raised by the material. But I will at least do my reasonable best, I hope. Can I then take you back to page 196C of the record, which is obviously Melbourne Surveyor's affidavit, because he doesn't agree with Mr. O'Connor. In part he does. He says that he resides in Kingston and he's an attorney at law, and it's probably helpful to have open the first affidavit from the appellant, because he says, I make no admissions to 1 and 2, which is that O'Connor is the owner of the premises. So those aren't admitted. I'm not sure anything turns on that. And that paragraph 3 is denied. He says he wasn't a client of the firm, Surveyor. And then, as to paragraph 4, he says that the plaintiff decided to sell premises belonging to him at Silverdene Drive, which are the premises, and asked if I was interested. I advised him I wasn't, and the plaintiff attended on Charles Hilton, real estate agent. Mr. Hilton telephoned to ask me whether I'd buy, told him I wasn't able to do so at the time. Mr. Hilton asked me if it was not possible to find someone to join with me, and he said he'd see, and that the purchase was going to be $225,000 valuation given by Mr. Hilton, which I was advised the plaintiff was satisfied with. I subsequently discussed the purchase with my brother, Noel Surveyor. He advised me he wasn't interested. I discussed the purchase of the property with Beryl Tomlinson, and she, for many reasons, wasn't interested in purchasing the property. She did indicate that her son was in a position to join with me, and after discussing the proposal with him, he expressed his willingness to be a co-purchaser. I subsequently conveyed this information to Hilton, who requested me to prepare the agreement. This was done, and I took it to Paul Tomlinson's home. He wasn't on the island, so his mother, who was not then an employee of this firm, signed the agreement of sale on his behalf. So in fact, if you go back to PC 11 to 13, it's not even Mr. Tomlinson's signature, but it was his mother, and obviously, no doubt, duly authorised. But after I had signed the agreement of sale, I sent it to Mr. Hilton for him to have the plaintiff complete the sale. This he did and returned the document to me. So that is the 1983 document that he appears to be talking about, but no one yet gets round to exhibiting it. I deny the allegations set out in paragraph 6 of the affidavit. If you go back to paragraph 6, this is where he talks about the 83 agreement. In particular, that the plaintiff signed the agreement for sale in the office of Silvera, and repeat paragraph 7 of my affidavit. And I state categorically there was no blank spaces in the agreement when it was signed by the plaintiff. So he says there was effectively a completed contract that was signed by both parties. But he then admits paragraph 7 of the plaintiff's affidavit, which was an advance of monies, but say that the monies were paid to the Bank of Nova Scotia, Jamaica Limited, based on the fact that the property was being purchased by me and Mr. Tomlinson. Further, that during numerous discussions with the plaintiff, I advised him that he should inform the Bank of Nova Scotia that the property was sold and that the bank could look to us for payment on account. I went to the bank and discussed the state of the plaintiff's account. And the Princes Street branch of Nova Scotia was subsequently closed, the account transferred to King Street, where I was treated as if I was the person who had borrowed the funds from the bank, as they were aware that I had to protect the purchaser's interest. Which purchaser he's talking about there, I'm afraid, has completely defeated me, because obviously it would be him. Subsequent to the signing of the agreement of sale, but prior to the preparation of the instrument of transfer, it was discovered that there was a breached covenant, and I was obliged to seek the services of a commissioned land surveyor for the purpose of checking on the land with the certificate of title and preparing the application for subdivision. The surveyor advised me that the plaintiff had caused a house to be built on land which didn't belong to him, and that one of the apartments, which was occupied by some undesirables, was built across the land which was reserved for a roadway. Then I obtained a copy of the certificate of title and checked at the offices of the local corporation to ascertain the terms and conditions for the subdivision. I also observed on the present title that all the land was transferred to the Minister of Housing, and no part of the land remained in the name of the original owner. After I discussed the position with the legal officer at the Ministry of Housing and requested he have the parcel of land transferred to the local corporation, thus enabling the corporation to transfer that portion of the property to the purchasers. It's taken approximately 4 years to have this matter untangled. It's only now approaching completion. Paragraphs 8 and 9, if you go back to 8 and 9, you can see that this is the 4 further agreements. Mr. Silver asked me to sign 4 further agreements, and he was told that there had been a sale. They're denied, and what he says is, I further say that the plaintiff was called on to sign 1 agreement of sale because it was thought that this would expedite perfection of the title, but the agreement was never signed by the proposed purchaser, and this course of action was abandoned on closer examination. So on his version of events, he has the overall sale to him, 1 proposed, can I call it sub-sale? I know inaccurately, but for these purposes, which is then abandoned because it wasn't going to help. And then relative to paragraph 10 of the plaintiff's affidavit, and can I just remind you that during the discussion leading to the purported sale, I wasn't advised to seek independent counsel. It's admitted that during the discussions, the plaintiff wasn't advised to seek counsel. However, he subsequently retained the services of other lawyers who advised of the plaintiff's decision. The plaintiff attended my office and advised me that I should continue to represent him. And then paragraph 11, which is that part saying that he's going to make lots of money out of this, says is denied. And I've set out here under a statement of account refuting the allegation. And you can see that he then has a purported sale to Cynthia Howard, 1 to Hilda Hall, 1 to Paul Piccott.
But I thought he said there wasn't a sale.
No, he didn't. Well, this is his description. And then 1 to Paul Dockery. And we have some papers relating to Dockery. Piccott is obviously the respondent in this case. And you can see that then rental amounts are described, which on the face of it is slightly inconsistent with the sales. Interest given to the purchaser number 1, which is Howard, I imagine, to cover rental. And then he says there's an amount owing on the purchase price by Piccott and Dockery. Now, if you look at Piccott's figures, he has $80,500. And if you remember from our first note, that was $95,000 was the purported sale price on that. And then he has a whole series of amounts, costs, etc.
So there was a deposit paid and then something in addition, presumably.
Well, we'll come to what Mr. Piccott says about it. I think he says part of that was that it was paid in 2 parts, neither of which appear to match the deposit. And then if you go over the page, he says he's paid a bit of money to Mr. O'Connor and balances or purports to balance it all out. Can I then ask you to turn back to the loose document that I handed you? And I hope next to the back of that will be the replying affidavit, 23rd of April 1990. Do your lordships have that? And then can I just take you through this? I reside and have my place, etc. He's read the supplemental affidavit, which he says was sworn to on the 19th and 20th of March, for reasons that I haven't been able to work out, but I assume it's only the same document, but that's only an inference, your lords, my lords, so that I've got that potential weakness. And examine quite carefully the attached exhibits and photocopy of cheques purportedly paid. And I'm afraid we don't have any of the exhibits. Based on these statements of account, I deny receiving, and then he denies receiving various amounts, and repeats that payment of my indebtedness to the bank was made from rent received from the 4 apartments over 6 years. And money is received from the sale of the apartments to 4 purchasers. Although he doesn't then condescend into particulars. By paragraph 17 of the affidavit of the 19th of March, the defendant stated that he paid to the Bank of Nova Scotia $125,000. I admit that the defendant had undertaken to repay the loan from the rent received, but the total paid to the bank was, and then he goes into that, and he exhibits a copy of a letter from the bank, signed, and I'm afraid on your Lordship's copy, you may be missing the bottom line. Can I just read it out to you, because my learned friend has a better copy, which is credit officer and marked KO1 for identification. So signed by the credit officer and marked KO1.
I'm sorry, Mr. Piccott, mine doesn't have the... I've just got the two affidavits and the letter from the...
No, my lord, you don't have the...
Oh, I see.
You don't have it.
Right.
My learned friend, very fortunately, managed to bring it over from Jamaica on Friday. So which is why I was going to come to this later.
Oh, I see.
But in fact, so that there's no secret about that. The letter simply says we provide additional details of the loan. It's not a letter that will take you further forward, but perhaps we can ask that copy be handed to you now. Can I ask? It's a copy of the affidavit, which is dated the 23rd of April 1990. I'm not sure, that doesn't look like the 23rd of April 1990.
This should be some rules.
No, it's this, yeah.
But is that not what we've just been looking
I
at?
think we've got that, haven't we?
Isn't that what we've just been looking at?
Yes, it is, my lord, but it's got the letter at the back. Don't worry, we'll sort that out.
Well, I think they may have it. I had one on... There was a document.
Yes, well, you may have it. Oh, I think my learned friend had already
Oh, is it here somewhere?
put it on the side.
I think we do have it, yeah.
Yes, thank you.
Oh, right.
This was on the table when we first arrived.
Oh, okay.
Yeah.
I'm sorry that everything is such an appalling mess. And you can just see, for what it's worth, the extra words that I've read out to your Lordship and the further document.
I mean, there seems to be a slight amendment to the affidavit itself.
I haven't picked that out.
Paragraph 3 of the document that we've just been handed, or was here when we came,
Yes.
has some amendments. They may not make much difference, or any difference.
I think, well, I'm not
Or
sure
maybe they're
that's-
comments. Or
No, I think that, be careful of that, my lord. I think that's in fact ex post facto lawyers writing.
Okay.
So, as far as I've been able to work out.
Indeed, there's lots of it.
Yes, which is why I've drawn that inference. But I'm afraid my learned friend very kindly bought this from Jamaica, and I'll just check with him.
Yeah, I think there are people who scribble it afterwards.
Yes, I think my learned friend thinks the same. He I'm afraid, won't be able to claim any better knowledge than that.
But the last page, the Scotia Bank, or Scotia Bank,
Yes,
that is KO1, is it?
yes. And you can see that top right-hand corner.
Oh, yes, I see. Thank you.
Yeah.
So on the outline chronology, if your Lordship says we're noting it up, I'm very sorry to ask you then just to note in then between the 19th of March 1990 and the 22nd of May, the 23rd of April 1990, which is the second affidavit of the appellant. Which brings us on to page 43 of the record, which is the order made by Mr. Justice Harrison.
Now, this was made on the basis of just of these documents, was it?
I'm afraid, my lord, I don't know. All I can say is that he signed it in chambers, and he says it's upon notice, and after hearing Garth Little and John Sinclair of Silvera and Silvera, and then he makes the order. But what, if anything, was argued or submitted, I'm afraid we're simply not being able to work out.
I mean, there are some affidavits by Mr. Little, I think, on the record. Anything in there which... No.
No, my lord.
No.
Nothing as helpful as that. I will show you what Mr. Little has said, but I'm afraid, well, certainly my firm recollection is it doesn't engage this. Can I take you then to the next date, which is the 5th of April 1991, and ask you to turn up page 148C.
Just on a very small point. In fact, the costs were paid, so were ordered. So
Yes.
in effect, he did make the order at little d of the application.
He did, but not in the terms as asked for there. He made a separate order as his own, as it were. But your Lordship's absolutely right. Can I then ask you to turn to page 148C? This is, as I say, the next entry on the outline chronology.
So what's your client's case as to the sub-sales at this moment? He seems to recognise there were some kind of sub-sales, query by whom or to whom.
And whether they were binding, etc. I think my understanding of all that was submitted, as I say, I've not been able to produce any documents, was that his case was effectively that there were proposed sales. Nothing went through because it all went wrong for reasons that have been given by Silvera. Although he signed lots of documents, he never actually entered into any binding contract for sale, and therefore he was and remained legal owner and beneficially entitled to the property, even though lots of people were living there renting it out, including, as it seems, some people called undesirables. But that's, you know, that is, as I understand it, the case, and in my submission is at least consistent with the documents, not inconsistent with the documents. The 5th of April letter is, in my submission, quite important because it shows what other people were also saying in an attempt to answer my Lord Carr's question by reference to other people. It's a letter between, if you look on 148D, Clinton Hines, who's a lawyer of Hines, Hines and Co., who perhaps unsurprisingly is representing Maisie Hines, who I infer is related but no further evidence, to Keith Brooks, who is the attorney for the Piccotts. And you can see, dear sir, flat number 3, St Andrew's agreement for sale. And we've got an earlier date. The second entry on our chronology, if you remember, was the April 88 draft agreement between Maisie Hines and Piccott. We acknowledge receipt of your letter of the 14th of March, accompanied by a cheque drawn on Eagle Commercial Bank in favour of our client for $10,000. This is the same cheque which we returned to you under cover of our letter, so they'd obviously been playing a bit of ping-pong with the cheque. In the above context, and on behalf of our client, we're acknowledging the receipt of a letter of the 25th of February 91 from Piccott addressed to Hines, under cover of which he remitted cheque number for $10,000 in favour of Miss Hines, and purporting to be a refund of the amount which she paid directly to Mr. Piccott on account of the purchase money for flat 3 pursuant to agreement to which our client and yours are signatories. So the Piccotts are apparently attempting to return the deposits. We understand the correspondence...
This is the April 1988 agreement, is it then?
I've inferred that, my lord.
Yeah.
And
as far as one can tell.
Yes, yes. If only because if you look at the top, read flat number 3 agreement for sale. And then we understand the correspondence from you and from your client to be an attempt to terminate the agreement upon a ground stated by you to be that Mr. Piccott will not be able to get title from his vendor, who it's alleged had no title to the property. So at that stage, Mr. Piccott is writing to his sub-sale saying, here's the money back because I can't give you title.
Now this is after Mr. Justice Harrison's decision.
Absolutely. And there's a reference to that in this letter.
And what's the evidence about who knew about Mr. Justice Harrison's?
This is what it goes to, really.
And is there any evidence that Pinos knew about it?
Piccotts?
Picots, yeah.
Yes, this letter, which is why it's, in my submission, important. Our client and the writer are not unaware of the emergence of certain obstacles which have slowed down the process of the issue of title. But our client, quite justifiably, remains unconvinced that title cannot or will not be given to the Piccotts. We're fortified in that view by the uncanny anxiety of your client to terminate the agreement to recover possession, and is still collecting rent from our client as owner-landlord, but has not even considered that our client's acquired rights under the terms of a subsisting agreement should have been given enough recognition to warrant some documentary evidence to support the allegation that the person with the proprietary interest in the land are disinclined or have refused to recognise the sale to Mr. Piccott and others. Has the legitimate owner, Mr. O'Connor, has the legitimate owner, Mr. O'Connor, expressed any unwillingness to transfer the flat to Mr. Piccott, or has he sought to recover the flat from your clients? Regrettably, like our client, we entertain sufficient misgivings about the sincerity of your client's declared position in the transaction that it is impossible to elevate the suggestion of their inability to get title above the level of a cunning strategy designed to extricate themselves from their obligations under the agreement, the motive being to take advantage of the present inflated value of the premises by depriving our client of her right to complete. Our client's ready and has been so ready to complete for several months, formal notice, etc., requiring you to complete within 30 days and asking for transfers. Both checks are enclosed. Our present stance is wholly inconsistent with a retention of these checks. Appears your client must do a lot more to conceal the motive to which we've alluded above. Now, of course, that was only their letter, but what it shows is that letter was sent then. What then happens is...
Is there a reference to the judgment here?
No, it's a oblique reference. We get express references later on in some of the proceedings,
Is it one of the certain obstacles which have slowed down the process?
I'd inferred it from that. And I'm sorry, when I was reading it in the light of the further affidavit, I perhaps put it to make a complete matching, whereas of course it's not. It's only
this is a notice to complete the 1988 agreement.
Absolutely, my Lord. And indeed, the next entry, Miss Hines goes further. If you go to page 115 of your record.
Right. Which page?
115, my Lord.
Yep.
These are proceedings. There are so many proceedings concerning this piece of land, but these are further proceedings between Miss Hines and the Piccotts, claiming effectively, it's a statement of claim, as you can see from the top, and she says she's an informal commercial importer. She resides at flat number 3. The first and the second defendant, the son and father, they reside in Castle Drive, Kingston. During or about November 87, the defendant offered to sell to the plaintiff certain premises known as Flat 3, being part of the premises registered as 968681, and the acceptance of the offer culminated in a written agreement signed by the parties during the month of April 88, which is where we've got April 88 from. The plaintiff will at the trial refer to the written agreement. Pursuant to the said agreement, the plaintiff made 2 payments of $10,000 each on the transactions to the defendant's attorney, Mr. Keith Brooks, which were applied towards the agreed purchase price of $240,000, which was the price your lordships will recall from the 88 agreement. The plaintiff and the defendant simultaneously agreed that the plaintiff would enter into occupation as tenant of the defendant, paying a monthly rental, thereby intending that the tenancy agreement would continue effective until completion of the sale and transfer. In about March 88, the plaintiff approached Victoria Mutual Building Society for a loan, and they asked for various documents so that the plaintiff's application for mortgage was obstructed because they weren't produced, and the defendant's attorney informed the plaintiff's attorney of his efforts to obtain duplicate certificates. The plaintiff, in the meantime, made alternative arrangements to pay off the balance of the purchase money, and since 88 has been ready and is still willing and able. And in spite of numerous inquiries by the plaintiff herself and her attorneys at law, the defendants have failed to put forward a timetable. Defendants, in plain breach of the agreement, purported to cancel the agreement for reasons they weren't able to make good title. The defendants have not lost their rights as purchasers. Alternatively, the legal owner, Mr. O'Connor, is willing to convey the property to the defendants in accordance with the terms.
We don't have. Do we have this letter that's referred to here?
No, my lord. Not as far as I'm aware. And with the terms under which the portion of the premises was to be sold.
So, in accordance with the terms what?
In accordance with the terms of the, I had an agreement under which but that was only a guess, I'm afraid, my Lord. Portions of the premises were sold. And certainly that's what actually subsequently happens, and we'll show you how that happened. The premises value $264,000 is now estimated at $450,000. So it's gone up, you can see, from the 240 to 264 and now 450. The defendant's purported termination is manifestly unfair. And I think that says unconscionable, but it's certainly the gist of it.
Unreasonable or something, isn't it?
Thank you, my Lord.
I can't read the rest of it, I'm afraid.
And then the defendants further, I think, terminated the tenancy agreement by issuing notice to quit, or purported to terminate it, I think is what is meant there, and sought recovery of the premises. And you can see that the plaintiff claimed at the bottom specific performance of the agreement for sale, damages for breach of the agreement, and an order of injunction restraining them from taking occupation. So that's Maisie Hines up in April 1991. What then happens is, if you go to page 123 and look at paragraph 7, and this is, just for your Lordship's note, this is in the affidavit of Keith O'Connor, which he swore on the 7th of March 2000. The first plaintiff, I, Pico, filed suit against Maisie Hines in the Halfway Tree Magistrates Court, and I'm informed and believe that judgment was entered for Maisie Hines against the first plaintiff by the Honourable Miss Elise Francis on the 2nd of March 1995. We have no judgment from Miss Elise Francis. Her jurisdiction was effectively its accountable jurisdiction in short terms. I mean, restricted rights to deal with land up to certain value in the magistrates' court, which for these purposes was before a professional judge. And that's the proceedings that, so you can see 2887 of 1992, which then finish in 95. The only other reference I can give your Lordships for that is at page 51 to 54. And this appeared, these
And it's a claim for rent, is it?
Well, I can tell you what it is, because it's rent and possession, effectively. Because it's, if you go to page 54, the report's asked to find as follows: the premises were let by the plaintiff, to the defendant by the plaintiff, as he was entitled to do. The defendant became tenant, the defendant was obliged to pay rent, and the defendant neglected her obligations. Now, if you look at the bottom of page 54, you see this is Keith Brooks, the plaintiff's attorney at law. And so these are only submissions by counsel, so your Lordships will have to be careful. But at least they give, albeit from the plaintiff's point of view, now the respondent's point of view, their perspective of what was going to go on in these proceedings. And you can see that the introduction is that the plaintiff is claiming as landlord to recover rent from the defendant as tenant. And the plaintiff must establish that he was the landlord, he let the premises as a tenant, the defendant paid no rent, and that the sum of $9,300 was not paid. And if you look at paragraph 3, you can see this. The evidence will show that the plaintiff was entitled to possession by virtue of an agreement of sale which he concluded with Melville and Severa, which was your page 11, the first entry on them. A landlord, and the plaintiff was therefore a landlord of the premises. Plaintiff formerly lived on the premises and did so pursuant to the agreement for sale, repairing and improving the premises, and that's picking up the point I think my Lord Clerk made to me earlier on. And then the defendant, who had been previously known to the plaintiff, expressed an interest in purchasing, and they agreed. The contract was entered into with the defendant for the purchase on the understanding that the defendant would take up possession as a tenant, paying $1,200 per month. The evidence will show that the defendant actually paid rent from 89 until November 91, when she stopped. The evidence will show that the defendant paid no rent for the period 91 to July 92, and by that offence the defendant denies that the plaintiff is entitled to any rent and gives her reason for not paying for the material period. The defence must be examined, and it says defendant denies owing rent, and that Pico is either the agent or landlord or owner of the premises, no authority to collect it. The rental was paid to the true owner of the premises, being Keith O'Connor. So effectively, Maisie Hines started paying rent to Keith O'Connor from, it seems, about November 91. And paragraph 13, it must be noted that the plaintiff's right to rent from the defendant arises out of his relationship with her as his tenant, he having let her into possession. The plaintiff is not basing his right on his being the agent of anyone. He bases his right on his position vis-à-vis the defendant as landlord. And secondly, on the equitable right to the property based on the above-mentioned agreement for sale.
Is there any reference here to Mr. Justice Harrison's order?
Yes, if you go to paragraph 15, again, it's a bit cryptic, but it's a lot more expressed than the other references. Even if, as is alleged by the defendant, the plaintiff wasn't entitled to rent as landlord because the legal right had reverted to Keith O'Connor pursuant to the order of the High Court in May 1990, and we know that Harrison's order was the 22nd of May 1990, and so Keith O'Connor was a true owner. This just does not dispose of the plaintiff's right as an equitable owner of the property, is what is said. So there is reference to it, my lord, but again, reasonably cryptic.
Do we have the allegation, the defendant's allegation, referred to in paragraph 15?
Sorry, my lord, you've lost me on that.
Well, the paragraph 15 is a response
Oh, right.
to the defendant's allegation based upon the court decision of May 1990.
Only, I suspect, in the sense that we picked it up before cryptically when she says in paragraphs 7 and 8 and 11 that the true owner was Keith O'Connor. You see in paragraph 11 she says that the true owner was Keith O'Connor.
On page?
Sorry, my lord, page 52. That's summarising the defence.
Yes, do we have the defence?
No, we've got the extract that is obviously set out in paragraph 11, but that's as much as we've got. I mean, they're admirable submissions in the sense that one can work out quite a lot of what went on, because we've got no other documents from them. And paragraph 16, you can see what is said on behalf of the Picos at that stage. Plaintiff is a bona fide purchaser for value without notice of any defect or other problem in the relationship between Silvera and O'Connor when he contracted to purchase the premises. This position of the plaintiff would give him an equity or interest out of which he would be able to create the tenancy, so that even after the court order, the defendant would still be obliged to pay rent to him. On no account can the defendant therefore deny that the plaintiff was in a position in relation to her which would enable him to collect rent from her. Evidence of Keith O'Connor will show that he was aware of this equitable position. He never denied the interest of the plaintiff. If in fact the rights of the premises reverted to Keith O'Connor, then the equitable interest of the plaintiff would be retained, with the plaintiff deriving title under Keith O'Connor. And it was out of this equitable interest that the plaintiff would be able to claim an entitlement. The matter between the plaintiff and Keith O'Connor is, as far as the defendant is concerned, nothing to do with her, especially in the circumstances whereas here there's already a relationship of landlord and tenant. And that's effectively the position that was put to the judge, which resulted in the 1995 judgment. This is Her Honour Elise Francis, who then implicitly, because all we know is the result, rejected those propositions.
And what's the answer to that?
To why they're it must lie, and we get closer to it when you look at Mangatul's judgment. It must lie in the fact that at the time no one treated these agreements for sales as actually giving any legal or beneficial or equitable rights. And that's certainly been O'Connor's consistent views throughout. Whether he's right or wrong is obviously didn't matter.
But that's an issue between the parties, all of that. And it wasn't resolved as between Mr. O'Connor and the Piccos.
O'Connor was no party to these proceedings. But you can see that effectively, because this does...
Nor was the issue resolved in his favour by the Harrison decision, was it? Because the Piccos weren't a party to that.
No.
So will these will all be live at some future potential trial? Yes?
Well, and that really is my point, my lord. That
You say there should be a trial of all these issues between all the relevant people who all ought to get into one melting pot together and let somebody sort it out.
Well, and sort of that, especially when you see what has happened down the line, which is, in fact, the appellant didn't take advantage of the increase in price. He sold to Maisie Hines for the $240,000 that she was prepared to pay, and she's got the property, and she's really, in some respects, the one who's going to be most in difficulty.
She's the crucial party to the whole.
And she did apply. I mean, it can fairly be said on her behalf that she applied to Jordan. She was the one who made
That was
the first
refused.
application.
Was that application refused? But we
Yes.
don't have a we don't have any reasoning
No.
in support of the refusal.
No, my lord. Nor do we have an appeal from it. Nor do we have a subsequent application to set aside that refusal.
But your client solicitors have been acting for her and Mr. O'Connor
Well,
for quite a bit
yes,
of time.
in fact, Miss Gale first came onto the scene on behalf of Miss Hines. Mrs. Gale first came onto the scene on behalf of Miss Hines, as you'll see later on. And the whole thing has then continued. And indeed, she then started to act for Keith O'Connor after there were difficulties about what Mr. Little was doing. But I hope that gives you at least a summary of what people knew at the time that this submission was made. And you can see, just for your lordship's sake, it's the 6th of February 95, which is just towards the end of those proceedings, obviously. But that evidences the commencement of the
Sorry,
proceedings.
what's the 6th of February 95?
Page 54 at the bottom. I haven't put that as a date on the chronology, because all I'm putting it in for is to show that the proceedings were commenced, and this is really the best evidence I've got of what the proceedings were about, as counsel's summary. Can I then take you on to the 4th of May 1993?
Well, we've got Maisie Hines's counsel submissions. Do they take the matter any further? From 56 onwards?
I'm sorry, my lord, if they do, I haven't noted them for those purposes. I suspect they give a better answer than I could give to my Lord Clerk about what the defendant was submitting. And you can see that effectively, if you look at page 56, there was the agreement for sale at line 20. Then December 91, the defendant was informed by Keith O'Connor that there was an order of the court stating that he was the owner and the defendant should pay no further sums, but should pay the rent to him. And so at least it fills in that gap which I had asked you to infer before, but I suppose can now make good. And you can see the evidence is summarised, and the plaintiff's case is dealt with at page 58 at the top.
So Maisie Hines has lived there, is this right, since April 1988?
Yes, effectively. And you can see the summary is probably the shortest place dated on page 62. Plaintiff is not the owner, the agent of landlord, or the landlord during which the period he pays rent. If, as the plaintiff alleges, he's the landlord, irrespective of the court order, then why is he stopped from claiming further sums? Defendant owes no rent and has receipts of proof of payment. She's paid the rent to the true owner, and there's no dispute. She did continue to pay rent for it.
So the issue really is who sold the flat to who and when.
Exactly. And an order for specific performance is, in our submission, not the answer to that problem. And really, that's why I did make the submission I did to my Lord Savile's direct proposition at the start, that if the Court of Appeal were doing anything other than applying that very strict test and no room for any discretion at all, then in our submission, any proper reasonable court must set aside that default judgment, because it makes no sense when you know the full background. Can I...
In general terms, am I right in thinking that Maisie Hines appears to have thought she'd bought it from the respondents in April 1988,
Yes.
or agreed to buy it, to be
Yes.
more exact. It then transpired as a result of the judgment of Mr. Justice Harrison on her view of things, that the Piccotts couldn't carry through that bargain.
Yes.
Whereupon she decided to buy it from the appellant.
Indeed. And at the same price.
Yes.
So the impression, and indeed, my lords, that's the next reference that I can take you to, which is page 45 of the judgment. We're on the bottom of the chronology at page 1 of the chronology that I handed out this morning. And if you look at page 45 to 47, you can see here the agreement for sale and purchase. Can I just say to your lordships, I hope a bit of time. If you look at page 197, I don't invite you to turn it, B to D, you see effectively the same agreement, albeit there's some slight changes as to who's got carriage of the sale. And it appears that that was lodged for a caveat, but this is the stamped version, and you can see the stamp in the top right-hand corner. And then the agreement is made 4th of May 93 by Keith O'Connor, who, rightly or wrongly, for these purposes, thought he could now sell this flat to Maisie Hines, and he does so, and you can see that the sale price is $240,000, vacant possession on completion, which is perhaps not surprising because Maisie Hines was living there, and other terms. Purchaser's attorney-at-law is given, vendor's attorney-at-law is Garth Little, who was representing Mr. O'Connor up until the unsuccessful hearing on the 2nd of March.
And had she paid anything other than rent to the respondents up till then?
To the respondents,
Yeah.
the only references I've got, she obviously paid rent because that's acknowledged in the submissions, and there's reference to those 2 cheques flying around of $10,000 each. But whether they were actually ever, I infer they must have been paid over at some stage because they're trying to send it back by way of cheque. But I'm afraid, my lord, I can't take you any further than that on the evidence.
Well, her case was that in her action against the Piccotts was that she had paid two lumps of $10,000 each.
Absolutely, yes. And you saw the reference in the letter to that. But it looks as if by this stage, she having originally started proceedings for specific performance, amongst other things, against the respondents, she's decided that, no, in fact, Keith O'Connor does have the title and I'm going to buy it from him.
So she bought it with the 240,000.
Yes.
And she'd paid rent to Mr. O'Connor for a time at any rate before.
Between November 91 to effectively May 93.
And apart from that, she paid rent to the Piccotts. And
Yes.
then there are these 2 further sums of 10,000.
Yes.
But they're not really relevant at present, are they?
No.
Yes, I see.
And can I just show you that page 49 is the receipt for the whole sum. And because it's relevant to the issues between the appellants and the respondents about whether they knew of this sale, can I show you page 34 of the record at D? And this is Maisie Hines' application for to be joined as a defendant to set aside, that Maisie Hines purchased for $240,000 and paid the price on the 4th of May 93, and the sale agreement was exhibited in evidence at the trial at Halfway Tree Court. So that's another piece of the jigsaw that you can put together with counsel's submissions. It may be that my Lord Sir Jonathan Parker is right, and I could have got that from the plaintiff's submissions, but I'm afraid I wouldn't read through it for that. And also, if you look at page 97 at E, the same point is effectively made, and this is in the affidavit of Pamela Gale, who, as you know, is my junior from Jamaica on this case, and at 97 letter E, she deposes to the same information. Because, as my Lord Clerk has noted, once that's appreciated, This has nothing to do with specific performance. It's whether or not the $240,000 should have been paid to us rather than to him. But in the interim, of course, the default judgment is in order for specific performance. Anyway, can I then go on to deal with my next date on the chronology, which is...
So if the position, pausing at this moment, if there had been a trial and your client had lost as between himself and the Piccotts, then the result would have been a financial payment, would it? Of the 240,000 or whatever.
Could only have been that, because, of course, their case was that they were entitled to sell it. I mean, you had Miss Hines' suspicions about why he wanted possession back. Whether that's right or wrong is neither here nor there. But if all the equities were ever to be discharged, it could only be the argument about the difference between the $95,000 and $240,000. And as to the $95,000, the evidence suggests that somehow, whether it was rent or whatever, at least $15,000 or $14,500 at some stage had been paid. Can I go to the top of page 2 of the chronology, 2nd of March 1995, and take you to page 148, letter H. 148H, sorry. It's in manuscript at the bottom of the page. And what I hope you find here is the order that was made by the resident magistrate. Before Her Honour Miss Elise Francis, after hearing Keith Brooks, Pamela Gale, and in fact, as we know from the submissions, quite a lot more beside, ordered that judgment be entered for the defendant against Paul Piccott. That brings me to the next date on the chronology, which is the first date in the action, which is before your lordships, which is page 1 of the record. And you can see that this is effectively the writ of summons from the Piccotts to O'Connor. And the general endorsement is that the plaintiff's claim is against the defendants for specific performance of an agreement by which the defendants agreed to sell and the plaintiffs to purchase all that parcel of land known as Unit 3, part of 26 Silverdean Drive. Now, of course, a short answer was that there was never any direct agreement between the plaintiffs and the defendants, but of course, that was never made. And that was 2nd of May 1997. By which time, if your lordships note, simply so that you can see where the representation, that Lila Parker is now the attorney at law for the plaintiff.
But I mean, neither the writ nor the statement of claim actually identifies the date of the alleged agreement, or the parties, or anything.
No. The next date, as your lordship has anticipated, is the statement of claim, which is the 18th of October 97, that's pages 3 to 4. Here you do have the plaintiffs, by an agreement made with the defendant, agreed to purchase effectively Unit 3. Can I just ask you to notice the sum, $96,000. I mean, where that comes from, I'm afraid it's completely beyond me. I've looked throughout all these papers and I've never been able to work that one out. In the transaction...
Well, perhaps it's a mistake for 95,000.
Well,
it's nearer 95 than 240.
Well, I would entirely accept that, my lord, until you get to paragraph 3.
Well, that would follow, though. If you made the first mistake, the next one would follow.
Yes, I suppose if you're not checking... Yes, I accept that could be the same reason. Although, yes. Anyway, in the transaction, Melbourne Severa acted as the defendant's agent, and the firm of attorneys at law had carriage of the sale. As a consequence of their entering into the agreement to pay the deposit, the plaintiffs made an application to Jamaica Mutual Life for a mortgage. Pursuant to the agreements, the plaintiffs were given possession and did extensive repairs and refurbishing at a considerable cost to them. And thereafter, the plaintiffs leased the premises. To date, the plaintiffs have paid upwards of $19,500 on account of the purchase price. Now, that's obviously different from Silvera's report because he had $80,500, but I'm not sure how one could represent that. There are 4 units bought by the defendant against his agent and attorney, Mr. Silvera. The defendant swore to the fact of having sold the 4 units, which I suspect must be a reference to the earlier affidavit, although, as has been noted as we've gone through it, he swore to a lot which wasn't necessarily entirely consistent. The plaintiff is ready, willing and able, and the defendant has wrongly refused to complete.
Now, is the only agreement referred to that of the 27th of July 1984?
As far as I understand it, my lord, because it's not identified, as you know, but the only agreement that I think is where the PICOs that's ever been exhibited mentioning the PICOs is that agreement, and mentioning flat 3 at the same time.
Is that the complete statement of claim? I mean, on the face of it, it seems that it is, but
yes.
It seems to end rather abruptly.
I think it was cryptic, my lord, unless, of course, and I couldn't say this hadn't happened, unless, of course, the page has got missing.
I just wondered really whether there was might have been any reference in it to the Harrison order in E353.
That I'm more confident of saying didn't occur, because one of the allegations made on behalf of Keith O'Connor, when represented by Miss Gale, was that there was non-disclosure to the court of that point. So certainly, by the time Miss Gale was acting, her understanding has always been, as you can see from the application she made, that it was never mentioned, which would be inconsistent with it having been mentioned in the statement of claim.
Well, indeed. And on this page, there's no mention of it anyway.
No, but your lordship's quite right. It does end rather abruptly, and one might. I mean, it
Might have expected a prayer for relief or something like that.
Indeed, and that, I mean, from what experience I have of Jamaican litigation, tends to get put in, and it's certainly not unexpected to find that a prayer is a page is missing on a record. So, but I can't say anything more than that. I'm sorry.
Suit E353 of 1989. That is the one that ended up with Mr. Justice Harrison, is it?
Yes, it is.
Yeah. Yes, it is. Yeah.
Yes. Yes.
Yep.
So that's a reference to his affidavit. Yes, that I think I showed you that my own friend had, because he swore that the defendant swore to the fact of having sold the 4 units, although your lordship's now seen all of what he swore. Can I then take you on to the 28th of January 1998, in pages 8 to 9. And in fact, to answer my Lord Sir Jonathan Parker's point, paragraph 9 of this affidavit, which is sworn before the order is made, there is reference to the judgment. But I'll take you through the whole of it. This is the PICO's affidavit, effectively in support of their notice of motion. You can see that at the top. In about March or April 84, we entered into an agreement for the purchase of land. Flat number 3, in parish of St Andrews, being part of the land comprised in the certificate of title, volume 968, folio 681, purchase price $96,000. Well, I'm afraid, my lord, even if one accepts my Lord Clerk's explanation for the difference between 95 and 96, one gets it now sworn, as it were.
Oh, well, once you made the mistake,
Yes, I entirely accept that. But on signing the agreement, the deposit was paid, and then you have attached a copy of the agreement, P1. And then, if you look at page 10, you get no exhibit clause was attached, as far as one can see. And that's why the only other agreement that comes close to matching it is then exhibited. But it doesn't...
So is PC 11, is that the exhibit to this?
No, there was no exhibit to it, as I understand it. And PC 11 is the best that I think the parties have been able to do in default of that. But as a result of having entered into this agreement, I applied for the loan from Jamaica Mutual Life. And he refers to special condition 2, And to be fair, if one goes to page 12, there is a reference to Jamaica Mutual Life on condition 2, special condition 2. The value of the property is fair. I tender a valuation report. At the time, the attorneys were Silvera and Silvera. I was placed in possession and got water and light, as a result of which bills are still in my name. I spent several $1,000s doing repairs to this house, so the immense work seems to have gone down a bit, but in any event, he says he still did some work. Felt secure that the property would be mine, because I was assured by the attorneys at law having character of sale that the subdivision had been approved. We expect the certificate of title should be available by mid-February. As a result of a judgment in a suit brought at the instance of Keith O'Connor against Silvera, affecting the premises, the ownership reverted to Keith O'Connor, and a part of the judgment recommended that the status quo in respect to the sale of the properties for which an agreement for sale was entered should remain and inure to the benefit of the purchasers. Now, that specific passage was repeated, perhaps your lordships might just care to note this, was repeated before Her Honour Judge Mangatal and is dealt with in the judgment, which we'll come to at the end of it, where the finding was effectively nothing was said. But whether anything expressed was said, at least there appears to have been Keith O'Connor's subjective recognition that Miss Hines couldn't lose out because he stepped into and completed the sale to her. And he says that this position has been recognised and adopted by the Attorney at Law, Mr. Keith O'Connor, as shown in his letter of September the 4th, 1990, exhibited in Mark P6. Well, we can't get the letter of the 4th of September 1990 wasn't in the record, but it's set out in the judgment of the Court of Appeal, so I will show you that when we come to submissions at the end. In fact, my lords, I mean, it may be helpful just to show you that now, simply so that you can have it noted up contemporaneously.
It's not PC 31 then?
Well, I'm very grateful to my lord. I've never found it in the record. I only had it in the judgment of the Court of Appeal. I suppose once you found it in the judgment of the Court of Appeal, stop looking, but it is that letter. That is the letter. Can I just check with the judgment in the Court of Appeal where they set it out in full? At page 342. Yes, it does appear to be exactly the same letter. And in fact, there's no excuse that the photocopying is fake because much of it is much worse than that, and I've been able to decipher it. So I'm sorry I haven't got that reference into it, but your lordship's absolutely right. That's 4th September 1990. Which is, you'll recall a meeting at our office. I pointed out a serious problem with the title, and he refers to encroachment, not in a position to pass title to you. You'll recall that by our letter we advised you some of 18,000 was owed by way of arrears. We now make a formal demand that you pay the said sum of 18,000 representing arrears of rent. It is difficult in my submission to read that necessarily as affirming the contract of sale.
It seems to suggest that he received a deposit from someone, or from Mr. Piccott. Second paragraph.
Not in a position to pass title, invited, yes, absolutely.
With a review of
to returning the deposit, yes. Although, in fact, the later evidence suggests that it was Silvera that only ever had the deposit. And indeed, that is at least consistent with Silvera's evidence. The explanation given for this was that it was all after Mr. Justice Harrison's judgment, when everyone knew that effectively O'Connor was the owner, whatever equities may have been operating, and I'll come back to that when I deal with submissions, my lord. But that's the letter of the 4th.
But this contains an assertion, does it, that Paul Piccott owed Mr. O'Connor rent.
Yes.
And that can only be on the footing that there was some agreement between them.
That whatever had been initially agreed by way of agreement for sale, if it was with him or through agent, it was now all replaced by rental matters. But I'm afraid inevitably one can only go so far on the documents and all the submissions that have been made without actually getting to the underlying...
I mean, these arrears of rent relate to what period? The 18,800, what period do they relate to?
My Lord, I'm not entirely sure, because if one looks at the letter there rather than the Court of Appeal's judgment, you can see the letter is dated 21st of June 1990.
Sorry, which letter?
It's page 31, my Lord.
No, that's the
4th of September.
There is a reference to a letter of the 21st June.
Yes.
Do we have that?
I'm less confident now than I would have been before, but I'm getting some assistance, and no, I don't think we do more.
So these are points that have been put against your client, but you say they should be put at a trial.
Well, and indeed, this, my Lord, which is where everyone seems, by this stage, everyone appears to know about the judgment of Mr. Justice Harrison. Rightly or wrongly, Mr. O'Connor believed that that meant that he had effectively the property and was entitled then to deal with it. There is then correspondence between Little and Pico, and Pico is not paying the rent, whatever subsequent agreements that was due under. And indeed, that was then all regularised by the subsequent sale to Maisie Hines, which he knew about. Now, of course, O'Connor wasn't a party to the proceedings in the Magistrates' Court, but a lot of these arguments about bona fide purchaser for value were at least rehearsed, as your Lordship sees. Now, we can't, in some respects, for these purposes, claim that that is really an issue estoppel. But you may get close to it, given that it all devolves through the land, which is as close as you can ever get to res judicata by not being a direct party. But all I need in my submission to show to your Lordships is that the agreement for specific performance, or the order for specific performance, is completely unworkable, and that there are very good reasons for trial. I accept it's more than just an arguable case, etc., given the delays that have occurred.
So what I say is correct, really, that these are questions for, you say,
Yes.
for resolution at some subsequent proceeding.
My Lord, which
So
will
the
be...
proceedings have gone forever.
Well, at least everyone will then realise it's not about the land, and then they might be able to sort it out. But other than that, I entirely accept your Lordship's proposition. It's taken long enough to get to this stage already. That was the affidavit in support of the notice of motions. Can I go back to page 8 to 9? Sorry, just to finish off the affidavit. There you have different figures given. They say that we paid $42,000 and as a result was given possession of the property, the premises. So I'm difficult to see where the figure of $42,000 has come from. It's asserted to in paragraph 11. It doesn't appear to match Silvera's figures or indeed whatever else we know. And that, my Lord, brings us up to the default judgment, which is page 7.
Well, what had been done, there'd been an appearance in these proceedings, had there?
Yes, well, apparently he turned up, we get this from further affidavit evidence, apparently he turned up to ask for an adjournment, didn't get it.
What, the appellant in person, when you say he turned up, do you mean?
His lawyer, you'll see this at page 7.
Mr. Little.
Garth Little turned up. And that's why Garth Little...
But was there any kind of entry, did you have to enter an appearance in this kind of process?
my Lord, I'm afraid I don't know enough there, because... Yes, apparently you need to sign a document saying that you're appearing.
And did that happen?
I infer so simply from the recital. Yes, I'm told that's the reason why.
And so what procedurally will be the next step? Once you've entered an appearance, what then you have to serve a defence?
Yes, absolutely, because there was a statement of claim, an unanswered statement of claim.
So there'll be a writ, then a service, then an appearance, then a statement of claim, or maybe the statement of claim before the appearance.
Well, yes,
And then there'll be an obligation to serve a defence, would there?
indeed.
And no defence was served.
Well, no, not by the 7th of 21st of May 98. A draft defence was exhibited in the support of the applications to set aside, but no defence was served, which was the default which entitled judgment to be entered.
And Mr. Little, well, you're going to come to the Magnetel judgment, aren't you? But Mr. Little gave some evidence about what happened in front of Mr. Justice Ellis.
Yes, he's made a subsequent affidavit, and as your lordship's already picked up, he gave some evidence about what happened at that stage. Can I? Well, perhaps I can just at the moment keep it in order, because and just show you what order was made on the 21st of May 98. Plaintiffs be granted specific performance between the parties that the property effectively known as Unit 3.
So, but it begins upon this action coming on for hearing.
Yes, sorry, Lord, yes. And after hearing Lloyd Barnett, instructed by Layla Parker and Mr. Garth Little, hereby a judge, and then the relevant parts, specific performance of the agreement for sale, defendant deliver the unencumbered certificate of title. If the defendant fails to abide by the terms thereof, registrar can execute, in conventional terms, and costs.
But this, in form, was it an application for judgment in default of defence, was it?
As far as we've got, in fact, there's where we get to the best evidence of what Mr. Little says. If one goes to the judgment of Veronica Judge Magnetel, which
This is the first actual judgment we've got in the case.
186.
It's the only one, I think. Yeah.
Well,
191, I think, isn't it?
186.
Yes, that's where it
And
starts.
this case, this case lasted in the northern amount of time. And I'll skip that if I may, I'll come back to it. The plaintiff, which is Paul Piccott, gave evidence at the top that he entered into an agreement to purchase the premises. He stated he bought the premises from O'Connor, and he said he'd rented to Maisie Hines in 88. He indicated he had a suit against Maisie Hines for rent. Miss Hines won. He said the premises were sold to Silvera and Thompson, and he purchased from O'Connor through those two persons. He doesn't appear to have mentioned anything about Maisie Hines' success. He let the defendant into possession in 88. He admits he signed an agreement to purchase, and there's where he deals with that. He says, however, that when he realised he couldn't pass title, he had his attorney-at-law cancel the sale and send the money back to the defendant. And, I suppose you can see that there was some correspondence about that. He indicated that in the Supreme Court a judgment was given against Mr. Thompson and Mr. Silvera to give back the property to Mr. O'Connor, but he claims that the court said Mr. O'Connor should continue the sale to him. The court and originating summons in respect of this suit were put in evidence during the defendant's case and through the attorney-at-law who appeared for O'Connor at the time. Mr. Little said the court said nothing of the sort, and the order certainly doesn't support Mr. Piccott in this regard. And that's that bit in the affidavit that I referred you to, that sort of a short bit. In all, out of a sale price of $95,000, he's paid $42,000. He said that when Miss Hines won the suit for rent, he sued Mr. O'Connor for specific performance. Exhibit 1. And then he goes on to deal with other parts. I'm not sure that it actually takes... I'll come back to this judgment, as I say, but I don't think we actually get anything further about the specific performance from Garth Little. We do later in an affidavit that...
Well, just a moment. I think it does. The judgment does deal with what Mr. Little described. 191, second paragraph.
Oh yes, yeah. He said at one stage Piccott was deemed a purchaser, and another he became a rent-paying tenant after property. Letters written by Mr. Little were admitted in evidence.
Yes, and then the next paragraph.
And Mr. Little described how, in respect to... Mr. O'Connor wasn't in court. He was present. O'Connor says that when the case came up, counsel for the plaintiff advised the court of a previous case with the Dockerys, who were also on property on the same basis as Pico, and that judgment was obtained in Dockery's case. This was a similar case. He said he was present, Mr. O'Connor was not. Mr. O'Connor was not there to give evidence, and judgment was entered in favour. Matter was not actually tried, and no evidence was heard. Yes, sorry, my lord. Yes. And indeed, we get very similar from his affidavit.
Well, then she went on to find that it was a consent judgment, or this judge went on to find it was a consent judgment.
How did she work that out?
That's halfway down 192. So we've got a default judgment, a consent judgment, and a judgment on the merits.
In the case...
End of the second full paragraph on 192.
Oh, I'm sorry.
I find that the order of Mr. Justice Ellis is in the nature of a consent judgment.
Yes, my lord. I'm sorry. Because I've been trying to extract information rather than opinion, which don't bind you. But I hadn't appreciated that.
There's no criticism, Mr. Davis.
And how one works that out from what occurred is very difficult. Yes. Thank you, my lord.
Anyway, there it is.
So that is the default...
Sorry, so I'm still a bit unclear about what was said to the court on behalf of your client.
Well, you've got the passage from there, which appears to be not much. You also have, if you look at page Garth Little's affidavit himself, I was going to bring you to this in order, but I'm perfectly happy to take you to it now. 149.
Sorry, I didn't catch that.
149.
149.
It's an affidavit where Garth Little says, he's the attorney on record, this is March 01, at the time of the hearing of the suit, I was not aware of some issues which should have been brought before the Honourable Court by the time of the hearing. At the time of the hearing, I was only aware of the suit against Silvera, filed in respect of the Supreme Court by my client Keith O'Connor, in respect of an attempt made by Silvera to sell without authority. And that's obviously how Garth Little was characterising it, whether rightly or wrongly we'll come to. But the plaintiffs herein have deceived the Honourable Court and misrepresented the pertinent facts against my client. At the time of the hearing, I didn't know that the first plaintiff had filed suit against Maisie Hines via that plaint that you've seen submissions for, and that a judgment had been given by Her Honour Elise Francis, and further that Maisie Hines had purchased the apartment from my client, as I was not the attorney at law who acted in that transaction. Had I known of plaint 2887 and the order obtained by Mrs. Gale, I would have brought this to the attention of the court during the hearing, that an appeal against the order obtained by Pamela Gale would have been the proper course for the plaintiffs to have followed. I am advised and believe that Paul Piccott, in an affidavit dated the 6th of February 2001, has implied he paid me purchase monies in respect of Silverdene Drive. I categorically deny receiving any monies representing the purchase price, and that's picking up that cryptic reference in the letter of the 4th of September, and state that the only monies I collected from Paul Pico was in respect of rental. In the circumstances, the instant suit is not only frivolous and vexatious, but an abuse of the process of court, etc., as it's all been determined before, he says in shorthand. So that's really the best evidence we've got as to what he says, either was said or not said and should have been said on the day. Can I take you to the next date, which is page, on the chronology, is November 1988. We're halfway down the page now. And it's page 95, if I may.
98, November 98.
November 98, yes, my lord, yeah. Sorry, did I say
said 88,
Sorry, my lord. In any event, page 95, just so that you know where this comes from. This is Pamela Gale's affidavit, which is at PC 91. It begins. And she says, that by an order of the Sutton Street Magistrates Court dated the 15th of July 99, the proceedings in plaints numbers 475898 and 525698 were stayed pending the outcome of suit 07497, and I exhibit the order PG4. I mean, what was outstanding at that stage is not entirely clear, because, of course, the order had been made back in May 1998, but it may have been appeals setting aside whatever.
These are all possession actions, or rent.
Rent and possession, yes. I mean, what he was, once he had, the closest we get to knowing exactly what they're about is really assuming that Mangatal, what happened in front of Mangatal was, Her Honour Mangatal was what happened before. Anyway, that's 98, and I suppose, in fact, the reason that you get the 15th of July 99 order is because the 12th of July, Miss Hines applies to be joined as a defendant. If you look on the chronology, just on my outline chronology, just below November 98, 12th of July, Miss Hines applies to be joined as a defendant to effectively the specific performance action, the action before your lordships, and to set aside the default judgment. And then it's for that reason that on the 15th of July, the Magistrates' Court possession proceedings are stayed. And can I just show you the application that was made? And it's page 33. And we've looked at it for another context, but Maisie Hines is applying to be joined as a defendant to the action for specific performance. And the judgment entered on the 21st of May be set aside on various grounds, and that they failed to disclose that a judgment pertaining to related issues involving the same plaintiffs, but with the defendant being Maisie Hines, was entered in the Halfway Tree Magistrates' Court. Shortly after the judgment was handed down in favour of the defendant, Maisie Hines, the file couldn't be located, judgment couldn't be perfected, and remained unsigned. I mean, we've now got at least the order, as your lordships know, and that in plaint 2887, he sued for unpaid rental and recovery of possession. Maisie Hines purchased from the registered proprietor, and that at the time when the instant suit was instituted, the defendant's attorney was unaware of that fact, and that this fact was peculiar to Picott's knowledge and that of the attorney at law, Keith Brooks, who represented him, and that at the time of instituting the instant suit, Paul Piccott was well aware and fully aware that 26C Silverton Drive no longer belonged to Keith O'Connor, as he'd sold the same to Maisie Hines. Now, it certainly seems from the evidence that he was aware of that fact. Paul Piccott was well aware of this fact as it had been revealed in the plaint. The plaintiff didn't file an appeal from the judgment. The instant action is frivolous and abuse process and res judicata, etc. And then if one looks at page 95, paragraph 25, and you can see there that effectively being set out by Pamela Gale, paragraph 26, and paragraph 25.
It's a very odd. Some of these dates are very odd here, aren't they? Because if one goes on to paragraphs 27 to 30 to 29 at least, those are about the stay application.
Yeah, they're the stay and the outstanding application. Because as your lordship notes, this affidavit is 9th of November 99. And
where it says at the top of page 96, the plaintiff's been set down for mention and so on, with a view to setting a trial date pending the outcome of suit 7497, which is also set for trial on Thursday, November the 11th. That's a reference, is it, to not the actual trial, but the application to
join.
For joinder?
Yes.
Yeah, I see.
yes. Yes, which was that unsuccessful application. If one then, going back to the chronology, and in fact staying at this stage, on the 3rd of November, you can see that Miss Hines made an application to stay the plaint, another one that had been issued, which was heard by Her Honour Straw, adjourned and later refused. And you can see that at 25, or 27, paragraph 27 to 29 on page 95, in that passage that my Lord Clerk has just referred to. You can also pick it up at page 186 from the judgment of Her Honour Mangatal, where at line 25 she records that Her Honour Miss Straw refused that application. But I'm not sure that anything that necessarily turns on that. So that's the situation. The next material date, if your lordships wanted to note that I didn't put in the date of her Miss Gale's affidavit because most of the information is set out there, but the 9th of November 99 was her affidavit that you look at pages 91 to 99. And in fact, to answer my Lord Sir Jonathan Parker's point, at paragraph 24 on page 95, there's a little bit more about what happened on the hearing before Mr. Justice Ellis. And it simply says that it was in the nature of a default judgment. It doesn't really tell us very much more, I'm afraid. Can I then turn to Miss Hines's action against the appellant, which is pages 127 to 128.
Now, were your solicitors acting on for both sides at this stage? Does say both Miss Hines and Mr. O'Connor?
At this stage, it doesn't appear that Mrs. Gale was acting yet for Mr. O'Connor. Right. I think that happened later. Perhaps I can just clarify. But if while instructions have been taken on that specific point, can I take you to page 127 to 129? And you can see that at this stage, Mrs. Gale was still only for Mrs. Hines. And you can see that the writ is against Keith O'Connor from Maisie Hines, and what is claimed is specific specific performance of the agreement made the 4th of May 93. Can I then take you on to the 1st of March 2000, and it's just for noting, the writ of summons was then served, and that there's the reference proving that is set out. And then on the 11th of January 2001, the appellant made an affidavit, which is at page 135. And he introduces himself and says he's obviously referring back to an affidavit or something, because he says, as for paragraphs 3 and 4, I repeat paragraphs 4 and 5 of my affidavit of the 7th of March 2000. Which, in fact, if one looks at the reference at page 138, yes, it is January 2001, but in any event, perhaps I can just try and take you through it.
So when it says at the top of page 135, further affidavit in response to the affidavit of Paul Piccott,
Yes,
which affidavit is that? Is that the affidavit in support of the notice of motion?
I infer we must be missing some affidavits, because if one goes to, I mean, he certainly refers to an affidavit also of 7th of March 2000, at paragraph 3. I repeat paragraphs 4 and 5 of my affidavit of 7th of March 2000.
We haven't got that, have we?
No. I mean, we got a lot more. The record's a lot better than when it first arrived, but I'm still sorry, there are massive deficiencies in it. But in any event, he says, so far as his material, he refers to the notice of appointment to hear the originating summons dated the 22nd of May 1990, a copy of the originating summons KOC2, which appears to be a reference back to Mr. Justice Harrison. I'm informed and believe that in '88, Maisie Hines entered into an agreement to purchase from the first plaintiff. I'm further informed and believe that Maisie Hines paid $20,000 and the sum hasn't been refunded to her. I'm informed and believe that by way of letter from my attorney, Garth Little, Miss Hines was instructed to stop paying rent as rental to the first plaintiff, as by an order of the 22nd of May 90, the court decreed that the purported sale was improper. I repeat, the matters mentioned in my earlier affidavit are extremely relevant, as I was registered proprietor, and although I was not party to the suit in the Halfway Tree Resident Magistrates Court, I did give evidence to the effect that he'd visited Maisie Hines and advised her not to pay, and I exhibited the rent I'd received effectively. And during the trial, the plaintiff made several approaches to me asking that I sell him the property. That's Pico asked him to sell him the property. I advised the plaintiff I couldn't do so as I already sold the property to Maisie Hines, and the sale agreement between Hines and myself was exhibited. I've never entered into an agreement for sale with either the first plaintiff or the second plaintiff, and I've never sold them 26C. In fact, the first plaintiff was a tenant in arrears with his rental. So, my Lord Clerk asked me, as it were, what was our characterisation of the situation at that stage, and I hope that was an accurate characterisation reflecting this. And that from the date set out in the statement, 18th of June, no monies have been paid to me as purchase price by the first plaintiff or second plaintiff. And I believe that a default judgment has been entered against me and that title to the property has not yet been transferred to Maisie Hines. I'm advised and believe that the first and second plaintiffs have sued Maisie Hines for rental and recovery of possession, and then he gives the details of that. As for paragraph 8, I say no conflict, as I've sold my property and she's paid me in full. I wish to transfer the property to her. My defence is I've never entered into an agreement for sale with either the first plaintiff or the second plaintiffs. I've never authorised Milburn Cervera to act as my agent in respect of the sale of 26C, never received any monies from the first or second plaintiffs. I entered into an agreement to sell it to Maisie Hines, and Maisie Hines is in possession. And my lords, obviously, when we come back to consider merits, we respectfully will endorse those propositions before your lordships. But that's the January 2001 affidavit. Can I take you then to page 139? And you can see here there is a further motion, it's described as, to set aside the judgment in default. It's impossible really to work out what all the earlier affidavits were going around relating to, unless those were in some ways related to the same applications. And further take notice that he intends to rely on the affidavit of Keith O'Connor filed on the 7th of March 2000. And you can see there another reference to the 7th of March 2000. And his affidavit of the 11th of February 2001. And he made a further affidavit on the 14th of February. Can I just show you that, which is at page 139? and it's not entirely clear what he's referring to, but it may be a reference to this statement of claim. Because if you go back to the statement of claim, which is pages 3 to 4, some, but not all of it, matches. And it goes to eight paragraphs before he then starts dealing with affidavits. But whether that's right or not, my lord, I'm afraid that's only the inference I've attempted to work.
So we don't have all these affidavits then?
No, I'm afraid not. I think we've got probably most of the material averments because there appears to be a lot of repetition in them.
And when you say in your note, appellant files a further motion to set aside the default judgment, is this the first one that is this his first application, or had he made one before?
Can I just check that? My recollection is that there was one made before, but that may be a cryptic reference to the first one from, which he certainly wasn't party to, made by the Maisie Hines.
Excuse me. The note that I made looking through this was that your client applied to set aside the judgment on the 7th of March 2000. And then he filed a further motion to set aside on the 14th of January 2001.
Yes, my lord, and that accords with my recollection. Why I've omitted it from this note, this chronology, I'm sorry, I can't explain, unless I have inadvertently deleted it. No. Can I give you chapter and verse on those points before? But certainly you've seen reference to the 7th of March 2000 affidavits, although we don't appear to have them to hand. Can I just very quickly then show you the 14th of February 2001 affidavit? And you can see that there's a lot of repetition. And page 141, at paragraph 8, he says, he makes no admission as to the lapse of time for filing of my defence, or as to the consent.
So this is in response to an affidavit we don't have.
Indeed, my lord. And all you can attempt to do is pick up, as it were, some references from that. And you can see he effectively repeats all that he said before, but nothing that in any sense takes matters further forward. At paragraph 24, he makes an averment that he has good grounds.
But where does he say why he didn't attend, or why he didn't do it?
That is in the further affidavit, I'm pretty sure, yes, I think that's March 2000, but in any event, hang on, is that March 2000? Can we go to 122, my lord? It may be that I've confused everyone here. Yes, this appears to be March 2000, which I'm afraid didn't then get on to the chronology, which it should have done. So in fact, between the 11th of January 2001 and the 7th of March and the 1st of March 2000, can you put the 7th of March 2000? And this is PC 122. We are missing quite a lot, but not in fact.
I just noticed PC 120. What's the date of that?
That's 1991.
Is it? Oh, right. Oh, well, never mind. Yes,
So that must be later. But if you look at 121, you can see that is the first, and my Lord Savile had it in any event. I'm sorry I've misled you all. I will tidy it up over the short adjournment. But effectively, this was the first application that he'd made, which was the 7th of March 2000, so in advance of the February 01 one.
I see it describes it as a judgment in default of defence.
Yes. And in terms of an explanation, my lord, he sets out a lot of the material. He says this, at paragraph 12, the plaintiffs knew and have known from as far back as 93 that the property didn't belong to me, as I personally informed him of that during the trial. And I told the court, effectively, that at no time did I attend court in the specific performance action, as I knew that I'd never signed any document to sell my property to Pico or Picos, and I'd informed Paul Pico when he approached me that I'd already sold the same to Maisie Hines.
Trouble with that is I seemed very bizarre. That's I've got a good case, so I decided not to go and make it.
Not sensible, my lord. Whether bizarre is...
I wrote foolish down against
Well, he
that.
does give another reason, which may be equally
yes.
questionable, but anyway, that...
And yes, he had the two reasons that he's always relied on, and I entirely accept, and I hope I've accepted in the case, that it's not a...
What's very odd, though, is that he had a lawyer there who didn't take these points. It's very, very strange. I mean, if he has this cast-down defence, even if they're bad defences, which he thought were cast down, he sends along a lawyer who completely fails to take either point. Because they aren't mentioned at all in the lawyer's...
No, and as far as Garth Little is concerned, he says he didn't know of the subsale, as it were, to Hines, or the judgment between Hines and Pico. He did know of the Silvera point.
And what is why he went along? At any rate, without asking his client what he'd like him to say.
Well, yes, perhaps.
Well, I think we'll come back to it at 2 o'clock.
Thank you, my lord. I'm sorry to take so long going through all the facts.